You are listening to the Shopify Solutions Podcast, a podcast for Shopify store owners that brings you concrete examples on how to build and grow your e-commerce brand. Your host is Scott Austin. He owns a Shopify agency called JadePuma. In this podcast, Scott will share his e-commerce insights and best practices with you.
Hey everyone, Scott Austin here, and a lot of my clients recently, and for the past couple of years for that matter, have been quite concerned about the ADA compliance notifications they've been getting from law firms. And, as you know, I'm no attorney, so I have opinions on this stuff, but I don't know what I'm really talking about. So I thought I'd bring in an attorney. And Brenda Pagliaro was nice enough to come on. She's an attorney and knows a lot more about this space and can help us Shopify store owners a little bit with it. Brenda, thanks for being here today.
Thank you for the opportunity. I appreciate it.
Oh, we really appreciate you being here with your expertise. Can you just explain for the audience a little bit about why we should be listening to you about this subject matter?
Okay. Well, I guess a little background. I am an attorney. I'm licensed in the state of Florida. I've been practicing about 33 years. Half of that time I practiced in private practice, doing a lot of different things, representing a lot of employers. And then I went into an in-house position for about 19 years. And I became the general counsel of a large Florida retail corporation. So I was involved in every aspect of the business, especially risk management, including, the website development. I didn't oversee it, but I was involved because we did, in fact, come into some website accessibility issues during my tenure. But when I was with that company, we grew 3x and we were almost a $900 million company. And then I decided after a long time, I ended up leaving to become a mediator and arbitrator, which is what I do now. So I'm a conflict resolutions person.
Oh, that sounds like a fun job, getting in the middle of two people on opposite sides and helping them solve a problem. Can you explain a little bit for us, a little bit of background behind, ADA, what it means, what the legislation is, and the history of it a little bit to bring people up to speed?
So the ADA basically stands for Americans with Disabilities Act, and that was came into law in 1990. It was amended in 2008 to kind of broaden the scope of what a disability is. However, it's the overall federal law that addresses discrimination as a whole falls under the ADA for people with disabilities. Under that ADA, there's different titles that apply. So in this case, web accessibility would fall under Title III, which deals with access to public accommodations and commercial facilities. So, and through litigation and through guidance from the DOJ, websites have been found in different jurisdictions to fall under the public accommodations provision of Title III.
And what does that mean for websites? Like, how is this being applied to, websites in general and, our audience here of e-commerce stores? What should they be thinking about making their websites accessible to be in compliance with the regulations?
So how does that apply to websites? So a lot of people believe like public accommodations and / commercial facilities dealt with brick and mortar, right? Your regular, retail stores or any type of store operating out of an actual place. Through the years, literally through private litigation and then some guidance from the Department of Justice, who kind of oversees the enforcement of this, it has been in different jurisdictions, including Florida, it's been determined that websites also are included in what one would call public accommodation. So what that means is anybody that can come in, if the public can access a particular spot, this law requires that the place make it more accessible and, user-friendly, accessible-friendly to everybody that would possibly or could possibly utilize that facility or that place or that website in this context. So any e-commerce website is essentially, for the most part, required to follow these accessibility rules that were put forth by the Department of Justice. And those rules basically kind of outline what guidelines people operating websites should follow.
Can you spell out what a few of those guidelines from the DOJ are so people can understand the concept a little more concretely?
Sure. So the guidelines are the Web Content Accessibility Guidelines, and they've gone from like 1.0 to 2.1 to 2.2. And then there's 1, 2, and 3, which are the levels. So currently what the Department of Justice is looking for is WCAG 2.2 AA. A lot of people in the industry have said 2.1 is AA can also operate as a best practice, but what the DOJ is saying is the 2.2 version. And what that includes is you have to provide assistive technology such as like devices, software, hardware systems, things of that nature to help people get accessibility to your website. So sometimes if somebody's deaf or if they're visually impaired, the guidelines basically direct you onto what you need to do to reach compliance for that 2.2 standard, which should enable almost anyone to access your website without any issues. It also requires certain things like you have to, have an 800, best practice would tell you to have like a number for people to contact. If they can't access, you provide them technical assistance, in essence, if they're having difficulty with your website. A lot of it also it talks about the color of the website, color contrast, personalized text, all different things like that. There's actually, I think I wrote down just a couple, just correct. It has text size, descriptive links, clear navigation, keyboard compatibility, and things like that. So it essentially gives you a roadmap, if you will, on the types of things that you have to do. And there's also when you're making these applications, you have to keep 4 things focused, which would be perceivable, operable, understandable, and robust. So all of these things that you're deploying have to really, best practice would be you're looking at all 4 of those things, and then you're using all of these tools to make the most accessible website you can for people with disabilities. I hope that helps.
I understand, there's a framework and all this stuff. What the challenge that I have with my clients, right? I've had many clients have been sued. The lawyers come after them, and I'm not going to talk negatively about attorneys in front of an attorney, but
go right ahead.
To say things are accessible and all that kind of stuff, it's really hard to implement that. And I've had sites who have, the accessibility apps. There's plenty of accessibility apps out there. You can download them from the App Store and Shopify really quickly and easily, and they still get sued. Or, they get sued and then they conform and then they get sued again. How does one protect themselves? Most of my stores have one concern at the moment, right? How do I not get sued, right? What can they do, specifically? Because, when you start talking about tabbing through the menus and all this other, stuff, which gets complex and really, really hard to measure and then also implement kind of thing. Is an accessibility app good enough to stop people? Is an accessibility policy providing phone numbers? What are some concrete things they can do to minimize, reduce, or eliminate the likelihood of being sued?
See, I'm a lover of risk management. So, I look at this as the perfect way to, risk mitigation is really what it is. Because are you ever going to eliminate every lawsuit? I'd have to say probably not. And a lot of the issues with these web accessibility cases is that there's a whole cottage industry in the legal community. I mean, throughout the country, and we have it specifically here in Florida because we're like the 3rd most litigious state in the country next to California and New York. And they were saying that 15 to 20% of the actual lawsuits for web accessibility are filed in Florida. And they come from pro se litigants, which is somebody who's unrepresented, or they come from law firms representing, a plaintiff. And sometimes the law firm will write a letter and say they're going to have a class action suit representing every deaf person or every blind person in the country. That's where I found myself a few years back, and that I got my first, basically a demand letter by a firm. And what I did basically in order to determine whether or not there was even any, concrete evidence or even, if there's any risk, in our website, I went right to my IT department. Now, I was in a large corporation, so most people may not have an IT department, right? But if you have a third party hosting your website, or you're responsible for doing your own web development or updating, what we did and what I suggested is we initially ran a report to determine where we were. Google has these tools available where you can run a scan of the website and it'll tell you where your errors are and it'll give you a percentage so you know the areas where you need to focus. And what we found in our website, every time we made an update, the pages that were either behind it or archived that were still accessible, they weren't properly tagged, so they weren't in compliance. So what we found was we weren't going deep enough in that process of correction. And so what we ended up doing was developing basically a risk mitigation plan. And so we ended up running these tests constantly. And all the while, this lawsuit is going on, right? So I'm telling the attorneys, well, we're in the process of, using our, making sure that our accessibility plan is in place, et cetera. But at that point, it wasn't in place when they first notified us. It ended up getting litigated, cost 6 figures, but I learned a lot from that. And basically what we learned was we needed a constant eyes on the website, constant attention to anytime we made a change, we had to make sure that it flowed through, appropriately on every single page. If changes were made, we needed to make sure that the team was, in compliance with what was required for every single change. We posted on the website that we were, in fact, working towards complete compliance with accessibility. We provided a technical number on, down the bottom on your banner where you could say, oh, if you need to, here's our homepage, here's
Yep.
our just, safety. You can go to technical assistance. So, or you could direct them to the proper technical assistance people that can help them through the accessibility portion of the website, where the area was. And also, once we got those calls, we had to make sure that they were, marked down and we knew exactly where there was like a weak link in the website. And so we would go back and develop it. We also hired a third party. And I know that small operators, small businesses, they don't have a lot of cash. And even in a big company, we didn't have a lot of cash to throw at it either because it was going to different areas of our business. We did find a company that worked with us, and it was a third party, and basically they ran scans. And when we basically became a customer of theirs, they were our vendor, and they would run constant scans. And anytime we had major changes, not every single change, but major changes that had to be deployed. And you can imagine in retail, you're constantly running sales, you're running promotions, all this stuff. We worked with them to constantly test after we made our changes to tell us where we're at. Now, if you're a small business and you can't afford that, you could also use a tool that there's tools for free that are out there from web accessibility companies. Google has tools. You can run them to just constantly see where you're at. Now, when we got our second lawsuit, I was ready for it because I said, hey, we were under a consent order from the prior lawsuit where we had to consistently do X, Y, and Z for, a year. After that, I think we got our second lawsuit after that it expired, but yet I told them, listen, we've already been in litigation. We already are managing our website. We already have made the improvements, and we've engaged this third party who is consistently working with us to achieve, the highest standards available. So that, believe it or not, acted as like a defense, not literally a defense, but it blocked that lawsuit. And basically they were saying, oh, okay, well, you're constantly doing this. And I proved to them that here's my contract, et cetera. So they knew that we are constantly working towards making the website more accessible and following the guidelines, the WCAG guidelines, and we were utilizing a third party. So that helped, because if you can prove that you're showing, good faith effort to consistently, work towards in your best practices, work towards having the best accessible website, and that you're following all of the guidelines, the accessibility guidelines, then that would put you in a better position. It won't act like as a pure defense, but it will help you with any litigation coming down the pike. And let's be honest, most litigation is about attorney's fees. And I'd like to believe it's about the people that are hearing impaired or visually impaired, but a lot of it is about attorney's fees. So, and chances are you're always going to have some. However, you can get out of the lawsuit a lot faster if you have all of these things in place. And I would suggest you have a policy in place that basically indicates that you are working towards achieving the best, accessibility guidelines. You're following what the DOJ and EEOC have put forth as the best guidelines. I would say that you should have a compliance statement on your website. I would also say that you train your team, you talk to everybody on your team to make sure that they're constantly aligned with working towards the same goal. And if you can prove all that and you're in a lawsuit, then that's going to help you. You'll settle it a lot faster.
Well, and correct if I'm wrong, but even when you settle it, it's going to take money, right? You're going to have to pay your attorneys to be on your side, and you're going to have to probably, pay cash out to the litigious side, whatever you want to call. I don't want to call them ambulance chasers, but whatever we're going to call those attorneys. Because I'm very disappointed, right? And it's just the reality of the fact, right? What I heard you say is, yeah, the internet or the world of attorneys is going to come and sue you over this ADA stuff, and you can't prevent that. What you can do is minimize it and prepare yourself for it But unfortunately, and this is true in most of the world, right? There's no silver bullet to protect yourself from this, but you have to be aware it's the reality that you're working in, being in the e-commerce space. If it hasn't happened already, it is going to happen, and you have to spend time and energy proactively preparing for it, and then you also have to spend time and energy reactively when you get, legislate or litigation or whatever the right term is against you on it, kind of thing. Is that accurate?
Yeah, unfortunately, it is, and because, we we refer to some of these attorneys as predator, attorneys, and that's because like they find a niche area to go after, and then they're relentless because it costs them nothing to run a scan on any website. And then they write a letter, and the next thing you know, you, the small business owner, is freaking out because you've gotten this letter and you're petrified, right? And for good reason, because at the minute create that letter, the clock's ticking on their end for fees. And so, although you can't, I can't say that you can prevent any lawsuit, especially in this area, web accessibility, but you certainly can mitigate your losses. You can stop the bleeding, as I say, by having a good program in place. And the key is really being proactive, not reactive. My first instance, we were reactive, and it costs money, costs big dollars. Or after that, any lawsuit or any demand letter I got from an attorney regarding web accessibility, I was well positioned because I was showing them I'm doing everything that anybody would require me to do, even in a consent order, by the DOJ. They wouldn't have me do any more than I'm already doing. And I'm doing that because after that first lawsuit, I set up a plan, like a risk mitigation plan. And we got everybody on board that was responsible for maintaining that website. And then because of that, that acted as a deterrent, for other lawsuits. I had a couple where I just wrote a letter and say, hey, listen, we've already been sued. We already have this plan. I've had people walk away from lawsuits, and this is our protocol. This is what we follow. Boom. And they went away without one penny spent. Other ones looked at just their fees and minimal $500 to a plaintiff or something like that. And keep in mind, the people that have been hurt by a lack of accessibility, they barely get anything. It's kind of like a class action lawsuit. You get your $1.20 check, and then the attorneys get a fortune. You know what I mean? So the downside is if you don't do it, and here's the downside. If you don't prepare and mitigate and get your ducks in a row to prove that you're doing, you're trying your hardest and you're doing all the, X, Y, and Z in order to make your website the most accessible possible. Of course, without creating an undue hardship on the business, right? Um, it helps you prevent a lawsuit, but it also, you have to worry about brand reputation. You have to worry about a lot of things in the days of social media. I mean, people will think nothing of going to social media and saying, oh, I have a deaf aunt, or I literally have a special needs niece, and it would be like me saying, well, my special needs niece couldn't get into this building because they blocked the, disability ramp or et cetera, or I can't even access a website because they don't have anything for the hearing impaired. And you'd be surprised from a social media perspective, you could take a big hit just from being looked at as somebody who is harming an already harmed population, right? So it's the best practices to make sure that you are doing something, and you can prove that you're doing something, that you're trying really to achieve the best accessibility for those who need it.
Yeah, just while you were talking, I had my calculator open and I calculated $100,000, which was, you said it was a six-figure cost for your business the first time you got sued, divided by $900 million, and it's 0.01% or so. Because it was such a large business, even though the 100,000 is a lot of money, percentage-wise, it was small. What I've seen happen is with my clients, who are doing $1 million a year, they're getting hit, and they're having to spend at least $10,000, which is their profit for the year, right? And they spend usually $5,000 for the attorney to defend them, and $5,000 to the predator, firm who's coming after them. And those are just approximate numbers. I've seen it, I haven't seen it much lower than that, but I've seen it much higher than that kind of thing. And it becomes like literally your profit's gone for the year when these things happen.
Absolutely.
Want to build a loyal community around your brand? Events and classes are the perfect way to connect with your customers, but only if your calendar looks as professional as your store. But embedding a Google Calendar just won't cut it, as the calendar looks clunky and doesn't reflect your brand. That's why we created Branded Calendar, the Shopify app that lets you embed Google Outlook or Apple Calendars in your store while seamlessly matching your store's branding. Originally crafted for our private clients, Branded Calendar was so successful, we turned it into an app for every Shopify store. With Branded Calendar, you're in control of how your calendar looks and where it appears on product pages, contact pages, blog articles, or even your homepage. Keep your customers informed with schedules for retail hours, classes, or events. You can even share multiple calendars to meet different needs. And the best part? Branded Calendar includes a robust, always free plan so you can start building community. Risk-free. Engage your community and stay on brand with Branded Calendar.
Years ago, especially in Florida, there was a whole group of attorneys that focused on nothing but ADA, but it was more access to buildings. Same under Title III, but they would literally have people go out to all the different facilities, and if your ramp wasn't the right, width, or your parking spaces were not appropriate, or they didn't have access to a bathroom because the bathroom door was too narrow, or when they did go in the bathroom, there wasn't a proper bar in the bathroom window, or I even had one where the paper towel dispenser was too high for them to reach. So all of these things. So that kind of was the beginning of a lot of this, and especially in Florida. And those suits were similar to this. You just really paid for them to go away, and you were given a period of time to cure the defect before you had to, say, pay out, or you could get out of it for a minimum amount and they give you 5 years to correct the defect. And the small amount to the attorney, small amount to the plaintiff, and then you're allowed to cure. I mean, there is discussion currently. I think in May of 2025, there was a bill, but in the House talking about doing something like that, possibly notice to cure, which would alleviate, some of the burden of litigation, because you'd have to give people the opportunity to fix that issue before you could, go after them. Of course, I don't think it's been passed yet. One thing it didn't do was provide a lot of businesses protections, right? It would affirm that your websites are part of public accommodations, which to date, jurisdictionally, different jurisdictions look at it differently. But that would make it, a fact, and then it would affirm it. But then it would also allow people the notice to cure. But I'm not sure whether or not that provision is going to make it into the final bill or when it get into the actual law. But people remain hopeful that it will help, deter some of this litigation.
Well, I might be a skeptic, but I don't think our Congress can pass anything these days. But maybe I'll be wrong, and they'll pass something to move the world forward a little bit. I've worked with some of these accessibility apps, like I mentioned before, and you had mentioned, I think it was WACGR or whatever the thing was, and 2.1 and
WCAG. Yeah.
Yep, and 2.2, and I've seen that they say, "Oh, we're 2.2 compliant" and all that kind of stuff. So I assume, this is a question for you, I assume that if I install one of those apps in my store, it's a good first step in having that defense that I need to put in place. Do you think that's accurate?
I would say that's accurate, provided you can back it up, right?
Yep.
So that saying that you're 2.2 compliant, or you're working in your accessibility towards 2.2 compliance, yes, that, and followed by a policy, because whenever you get sued, they want to know what's your policy and how do you back up this claim you're making on your website, and what do you have to prove, what documents that they're legally entitled to get, what documents can you produce that basically show that you are in fact working towards or have been declared 2.2, we've reached that level of compliance. I wouldn't tell someone to go slap a statement on their website that wasn't accurate, and I think a lot of small business providers also, a lot of them don't host, or maybe they do now, but my understanding was that a lot of them don't host their own websites, right? So if that's the case, you really need to work with your vendors to make sure that they're striving for the same level that you're striving for, and whatever you're doing to maintain your website. You know what I mean? Because I think one of our problems was that the platform we were hosted initially, we changed, but the initial platform was creating a lot of problems for the website as a whole that we weren't even able to go in and correct, so we had to work with that vendor, which made it really challenging. And then we ended up, moving over and hosting our own platform and basically rebuilding it. But even when we rebuilt it, we still had to constantly keep a quality assurance plan in place. I call it risk mitigation, but it's also a Q&A process to make sure that every change you're doing is hitting the layers lower. So make sure that somebody can, they run a test on you to find that page 137 in your website is non-compliant. You know what I mean? And I think there's realms. I think courts have gotten a little bit more understanding, the efforts that it takes a small business to do. And if they can show undue hardship, like you were saying, like, okay, my profit margin is minuscule, and now I have to pay lawyers and I have to pay my attorney, their attorney, then I have to pay a third party to help me fix the issues on my website, all of that. I mean, I think that can help them in a sense, because undue hardship has always been kind of an argument when it comes to enforcing all different types of things and laws and things like that, rules, regulations, ordinances, things like that. Because sometimes it's cost prohibitive, like we were able to go out and hire a third party that constantly worked with us. And they literally had a library to learn. So we were learning all the way along on how to do it ourselves. So inevitably they should become unnecessary. So we went from like a weekly to a monthly scan to a quarterly. And when I left, they were still doing quarterly scans, but we had learned how to do and look for everything on our own. So we were able to really absorb a lot of that in order to prevent any future lawsuits.
Yeah, as you have already aptly said, right? That's a lot of overhead for small stores. I have a client right now who got sued just a few weeks ago, and it's just taken over her life just to educate herself on the process and what the rules are, and then having to find attorneys to defend and back and forth. And it's just like, it's ruined her December. And that's true for many, many store owners. But it's one of those, it's unfortunate, but it's one of those things. That's the world we live in, right? In my understanding, very few of these actually get to the courts because they all get settled before then. Is that accurate?
That's accurate. And I mean, I think a majority, probably, I mean, on average, about 80% or higher cases settle, right? These type of cases always settle. You know why? Because when you get into e-discovery and all of those things, they're very, very expensive. So a lot of law firms don't want to absorb those costs. Unfortunately, there's now companies that will fund a law firm's cost. So the law firms are, well positioned to go after businesses, but they're going to more in those circumstances. I think they're going to go after the bigger fish, right? Like a Walmart or, just a larger business, like the business I was with, they'd go after, but not necessarily the mom and pop. So a lot of the mom and pops are going to settle out, and one thing I feel bad for people is as soon as they get that letter, there's always a provision in there. More often than not, at least I shouldn't say always, but more often than not, there's a provision that they're seeking an injunction to prevent them from continuing their website, which of course could be their entire business. Courts are very, very, very reluctant to issue that type of injunctive relief unless it's egregious. The actions that were done are egregious. And in most instances, that would not be the case. Although I could see where people would lose sleep over it and they would be burdened trying to figure out, what do I do and who do I go to? You want to go to somebody that specializes in ADA litigation. There's a lot of firms here in Florida that do specialize in it. I wouldn't go to your business lawyer who's not well versed in websites and ADA, but he or she may be able to direct you to somebody that has that expertise. Because you know what, sometimes they can just write a letter and say, listen, our margin is very small. This is what we have. Even if you take us to court, you're not going to get more than that. They can negotiate it up front and maybe settle something for, like you said, 10 grand, which is a lot to a small business owner. But it stops the bleeding on your defense attorneys. It's, hopefully can get rid of it quick and as painless as possible, although you're still going to feel it on your bottom line. I have an accounting background too. So I'm always thinking bottom line. It's really a shame, but I really would encourage everybody that if you're doing it, using the best processes possible that you can avail yourself to keep your website up to speed and be in compliance as best as possible with the WCAG guidelines, 2.1 AA or 2.2, if you're fortunate enough to be able to get to 2.2 AA, and put that notice on your website. It will help. The government goes by, their standard is WCAG 2.1 AA, right? Yet they want to hold everybody else to 2.2. And now they're in the process of crafting 3.0. So even all this is changing as we're getting, as technology is, becoming more a part of the laws that are made. Keep in mind, most of the laws that we're going by, are archaic because they really haven't been updated along with how innovation has occurred, right? So we're always behind the eight ball when it comes to law, which enables these little cottage industries to grow until somebody puts a stop to it or at least curbs it a little.
Cottage industry makes it sound so pleasant and nice, but they're not that way at all. So I had one client who, just to illustrate to the audience how predatory it is, right? You talk about the predatory firms, and I had one client who found out that a predatory firm was putting a claim against them from other attorneys who saw that and then said, "We will represent you in this case." So it kind of looked like, and I don't want to say this is fact, but it kind of looked like, they're all in cahoots together, where the one law firm is going to sue you and the other law firm comes in and go, "I will help you and represent you in this litigation type of thing." So it really didn't look legit, or not, didn't look honest. Let's put it that way.
Yeah, one thing about the legal profession, and lawyers will hate me for saying it, it's a little incestuous. So I mean, think about it. Most of our politicians are lawyers, so when they're there crafting all this legislation, they're not doing it they're protecting themselves first, right? So these laws are written a lot of legalese, and they're written in a way that it's difficult to really understand, for the layperson. And even as an attorney, sometimes I'm reading it like, who wrote this? This is horrible. It doesn't even make sense. And that's what happens, So I always used to say we should really pass a law that says that you can't have more than 10% of lawyers making up the legislature. And that would maybe help with, laws being passed that are more realistic, but I doubt that will ever happen. But it would be a great idea.
It's a great idea. I agree with you.
Yeah, I think it's a great idea because it's always bothered me. It's always bothered me that, it's like you're constantly giving yourself protection, along the way. You're never going to be out of a job because you're crafting a law that somebody can't even understand. So when you violate it, you're like, where did I violate it? If you're a layperson, and then they explain it to you and you're like, yeah, but that's not how I read.
You're still talking Greek to me. Yep.
One thing I would say though, if somebody does reach out and say, I'm going to defend you, I would be a little cautious, because I'd want to know, is there some kind of referral fee background going on in the background or what? But then, there are some defense firms, and I know some of them, that literally when they go on the docket, because, you can get every case filed, right? So they use that as a marketing to go out and say, oh, I see you're being sued. They may not have any arrangement with the other firm. They're just looking at all the cases that have been filed on the docket. If it's just a demand letter and somebody solicits you, then I'd really question whether or not there's some kind of funky thing going on.
Yep. I think it was to the docket, like you're saying.
On the docket, yeah, because I can get a printout of every case that's filed, especially in federal court. And mind you, a lot of cases are filed in federal court, and that's like a rocket docket. They don't mess around. And then other cases are in state court, which moves a little slower than federal court. But, I was reading recently that there's like 1 billion people in the world that have some version of a disability, or have accessibility issues. So you look at that and you think, that's a lot of people. You have to do what's necessary to make things accessible. But by the same token, there's an uptick in these lawsuits in 2025. They say that it's almost 20% higher already 6 months in, or 9 months in 2025 than it was in 2024. And that's kind of the problem. It just feeds on itself unless it gets quashed somehow.
Yeah. So if I was to summarize what you're telling me here so far is, hey, e-commerce store, there's a reality that you are required to be accessible.
You're legally required.
Yep. And you are going to get sued because of this predator ecosystem we're dealing with. But there are things you can do to mitigate it. And it's going to take you time and energy. You're going to have to be smarter about the rules and all the nuances in it. You maybe install some technology, definitely have some process and policies that you document, and that will help you mitigate, reduce, defend, but it's not going to be a silver bullet, and it's not like you're not going to hear from these people in the future. Is that an accurate summary?
Yes, I'd say that's an excellent summary, And for your audience, there's if they really want to understand a lot of different things, a good place is like section 508.gov, which is where the government's perspective on what they're requiring the government to do. Of course, they want, the citizens to be at a higher standard, but still it gives you good guidance. There's companies out there like I have not worked with Level Access, but I do know that they provide great information to, the industry and to people that are looking for any information on ADA web accessibility. They're a great resource. DeQ also has great resources out there. So there's a lot of, and of course you can Google it and learn about it. But a lot of there's companies that specifically focus on this. What is it? Accessibility is one of them. But, you have to be careful if you're going to utilize these companies, make sure that they're just not patching over things and that they're actually correcting the issues with the site, right? But a lot of these companies do offer a lot of information that can help people as like a guideline on where to go or where to find the information, or, where to learn a little bit more about what their obligation is with their website.
Yeah. It's just that, the challenge with Shopify store owners is they're wearing a dozen hats, and now they've got a 13th one we're adding to the mix. But it's just the reality of the world is what I'm hearing from you is, you can't stick your head in the sand. You're going to have to be smart about this one. So if people wanted to get a hold of you in the future, Brenda, how could they reach out to you?
Probably the best way to do it, I have an email. It's really a Gmail. It's brendapagliarollc @gmail.com. I'm also the mediation company is Mediation Works Florida. So that's Brenda at mediationworksfl.com.
Well, I appreciate you sharing your time and expertise with us on this topic today.
Thank you. I appreciate the opportunity, and thank you for reaching out. And I wish everybody who's looking to get help like you're providing them, that they're able to find it.
My pleasure. Thanks a lot.
You've been listening to the Shopify Solutions podcast with Scott Austin. This podcast is brought to you by JadePuma, a Shopify-focused agency located in San Diego, California. If you like what you heard, please leave a review and subscribe on iTunes or wherever you get your podcasts. If you'd like to work with Scott on your brand, email him at scott@jadepuma.com.